Welcome. Welcome back. Welcome back. We were supposed to be covering the actual hearing itself, and we have discovered, sadly, that it appears that it is not streaming. And I tried to get the Zoom meeting ID so that we could maybe throw the Zoom up. No luck. So what we're gonna do, instead of canceling the live, I figured at the very least, what we can do is go ahead and do what we do when we're not streaming a trial or a hearing, which is read the documents. So they're pretty interesting. If you guys don't know, we are covering Ashley Benefield, and I'm Bob Mata, your host here at Defense Diaries. I forgot to say that. Make sure that you're liking, sharing, subscribing, commenting if you're on replay. That really helps get the lives out into the algorithm as well. So, if you're not aware, Ashley Benefield was convicted of uh, murdering her then husband, Doug Benefield, back last month. And subsequent to that trial coming down, and we know that she was sentenced already. Uh, Once again, we have some bizarre interactions with the jury and social media. Social media is rearing its ugly head in the courtrooms across this country, and the Benefield case appears to be uh, guilty of that as well, potentially. So let's pull up the documents, read through what they're alleging may have happened here. Um, the one thing that's becoming very, very obvious to me is that the issues with social media and the courts and the administration of justice is going to have to be dealt with in some way or another. It's one thing to come on and do lives and talk about cases. It's another thing altogether when people that are involved, actually involved with the trial, are whether they be witnesses, whether they be juries, whether they be litigants, whatever the case may be, going onto social media and either posting things and or reviewing things that they're not supposed to be reviewing, especially witnesses and jurors. It's going to have to be addressed, and I just don't know how they're going to do it. Like it's not an issue that's going to get easier to deal with. It's not something that's going to go away on its own. It's going to get worse way, way before it gets better. So typically when we have issues like this in the judicial system, what we have to do, we being the legislatures, they have to try to figure out some laws that are put into place because otherwise, I mean, the whole system can break down. There's just too much accessibility short of, like, I just can't see them when they're sequestering jurors, just taking all of their devices and blocking them off from the world. We just live in a much different world than was ever contemplated when we started our criminal justice system back when we drafted the Constitution. Obviously, the forefathers were not going to be able to foresee that this is where we'd be, that we'd have all this access to all this information, instant communication, exchange of ideas instantly. It creates a really dangerous precedent in terms of people being able to get fair trials, and ultimately, if we're going to start having cases overturned because of these types of issues and it's becoming a huge cost for taxpayers, which they are. I mean, if cases have to start getting tried again, it's millions and millions and millions of dollars. And it's not just an issue that is, local to any one jurisdiction or state. It's happening all over the place. I mean, we are like right now, I'm having a hard time thinking of any more recent cases wherein there hasn't been some kind of issue with social media or people watching YouTube streams, like witnesses watching them, after the day in court before they're testifying. And it's problematic. The entire purpose of us asking for sequestration of witnesses, meaning that they can't sit in prior to them testifying, is because you don't want them hearing what somebody is testifying to because it could affect the way that they testify. That's the entire purpose of it. That's why we always ask for witnesses to be sequestered during trials. I mean, there's a few exceptions. Obviously, victims' families, we want them to be able to sit in on the proceedings. Many times, the state will try to accommodate victims' families if there's not statutes in place wherein they're given the right to sit in, whether they're testifying or not. Um, but lay witnesses and other types of witnesses are not allowed to be in there typically, as long as the attorneys ask for that to happen. And I've never seen a circumstance where a judge has not granted it. So it's a problem. It's a real problem. So yeah, let's dig into the documents and see what they're alleging. I saw these when we didn't do a live when they came about, when these allegations came up, but they're interesting and disturbing, to say the least. Because this one goes directly to the jurors, and the jurors are worse than the witnesses in terms of them accessing things, because that's not good. That just the ability for them to be able to see things and hear things that they're not supposed to be seeing and hearing, in terms of them being, kind of that blank canvas, or just unformed clay that you're hoping that you're going to get with jurors without outside influence having an impact on them, is destroyed. I mean, like what is the point of having motions in limine about things that the jury can or cannot hear, if they can just go online and hear it anyway? Like, it makes all of it seem kind of superfluous. Um, I mean, it's hard to I certainly can't say that it doesn't, Carol. I mean, I don't know. I don't know how it affects. It can't be helpful. I mean, we fight so hard as lawyers, and I'm always talking about how the real war in any case is the pretrial motion phase, because that's what's decided what's going to be admissible and inadmissible pursuant to the rules of evidence. And if you have just this kind of open book, like open source, like way for jurors to be able to access information that they're not supposed to be seeing and hearing because of whatever legal reason it was kept out, is a real problem. I mean, it's really undermining the entire system. It's a huge, huge problem. And, YouTube's not going anywhere. Twitter's not going anywhere. Social media is not going anywhere. So, I mean, we're going to have to address it somehow. And that's just a very difficult question to answer. How do we do it? It's not a real super obvious answer as to what we can do. All right, so let's go through this. They're not super lengthy. So Ashley Benefield's attorneys filed a motion to interview jurors, and they cite Rule 3.575 of the Florida Rules of Criminal Procedure, in conjunction with, as part of her motion for a new trial, they hereby move the court to conduct interviews of the jurors in the instant matter. Now, just so you guys know, and I know that we've told you here many, many times, kind of the process with filing your appeals. Before you file your direct appeal, there's always going to be a motion for a new trial. Like, some lawyers take it very seriously. They dig in. They really try to point out a bunch of facts. But what you're doing there is you're asking the judge to find that whatever may have happened, whatever allegations are taking place in the motions for new trials, that the judge ignore the verdict of the juror. So as you can imagine, that's very, very rare for that to ever happen. But it's a necessary evil in terms of getting your appellate rights set in stone, and it's the first step that you have to take in terms of filing appeals. So, paragraph 1, on July 30th of 2024, the jury rendered its verdict. Wow, I was already back in the end of July. Time sure flies. Time sure flies. 2, evidence has come to light indicating that the verdict may be subject to legal challenge due to jurors' misconduct. The alleged misconduct not only violates the court's explicit instructions, but also infringes upon the defendant's constitutional right to a fair trial and impartial jury and subjects the verdict to legal challenge. So now we're going to get into the details. During jury deliberations, a YouTube user with the handle That Hoodie Guy posted comments in the Law and Crime Network's YouTube live stream of the verdict watch. These comments contained real-time information that could have only originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Miss Benefield's right to a fair trial. The comments posted on July 30th, 2024 reveal at 10:20 p.m. At 10:20 p.m., 10 minutes before the parties were notified that the verdict had been reached, that Hoodie Guy posted a comment saying, "Verdict incoming." B, at 10:25 p.m., that Hoodie Guy posted a comment stating, "Per sources, 5-1 guilty, with the man stuck on not guilty or manslaughter." C, at 10:27 p.m., that Hoodie Guy posted a comment stating, "My sister snuck in a flip phone." I mean, who his sister is obviously one of the jurors, allegedly. D, at 10:28 p.m., that Hoodie Guy posted a comment stating, "I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty, with a man stuck on not guilty or manslaughter." 10:28, that Hoodie Guy posted a comment stating, "My sister snuck in a flip phone in, and she texted me, 5-1 guilty, may compromise on manslaughter." At 10:30, a mere 2 minutes later, after that Hoodie Guy posted that the jury may compromise on manslaughter, the jury returned a compromised verdict of manslaughter with a firearm. 6, the timing and specificity of these comments, followed by corresponding jury actions, strongly suggest that good Hoodie Guy's information originated from within the jury room during active deliberations. This represents a breach. Oh, hold on, I'm going to slip it over to scrolling. A breach of the jury's sworn duty and impacts the fairness of these proceedings, subjecting the verdict to legal challenge. 7, this alleged misconduct raises serious concerns about the integrity of the jury deliberations and the reliability of the verdict. It raises questions about a jury smuggling an electronic device into deliberations, which is not permitted in the jury room. B, real-time communication of confidential jury deliberations with non-member juries or non-jury members. C, influences external to the evidence presented during the trial may have influenced the verdict. Now, that's the one that I'm most concerned about. D, access to unauthorized materials affecting the verdict. E, the overall integrity of the fact-finding process being compromised. And then paragraph 8, the prompt removal of these comments from the verdict watch on the Law and Crime Network's YouTube channel live stream further underscores the seriousness of this potential juror's misconduct. In addition to the above, evidence has come to light indicating that the verdict may have been subject to legal challenge due to Juror 15 being untruthful during voir dire by falsely representing that she had not been a victim of a crime. Her son had been charged with a crime, and she had involvement in the child custody / domestic abuse matters. 10, Juror 15 completed a jury questionnaire under the penalties of perjury, which asked, have you or a member of your immediate family been a victim of a crime? Now, we always ask those kind of questions during voir dire, always. And it's one of frankly, that's one of the things that the judge asks is like on the front end. It's like, they'll name witnesses, whether it be cops, whether it be the lawyers, whether it be people that are going to be testifying, whether it's, the defendant. If it's a civil case, it's the defendant or the plaintiff. Those are always the first things that are asked of the jurors before the lawyers even start asking questions. Those are by the judge so that they can kind of weed out any kind of jurors that may have issues or are going to be jurors that would be removed for cause anyway. So, and we rely 100% on jurors being honest about that. Like that's the only thing that we care about, really, is that they're honest, no matter what their answer is, because there's no wrong or right answers. It's just we need to know if people have potential bias just buried in their brain. And, you know, people that have gone through similar events that, maybe the subject matter of the trial, it's a problem. It's a problem. We all form biases in this world. We're humans. If we go through certain things, we're going to develop a bias, especially if it's a negative impact on your life, you're going to develop a bias, even if it's subconscious, even if it's not something that you're sitting around thinking about all the time. Um, all right. So juror 15 responded untruthfully to the question by omitting that one, she had been a victim of a crime, a battery, touch or strike, domestic related on February 20th, year redacted. I think it turned out that the year was quite a while ago, but still, doesn't matter how long ago it was. When her live-in boyfriend intentionally slapped her in the face with an open hand 5 times. And that two, her son had been charged with felony battery against his girlfriend on August 31st, year redacted, for which juror 15 was the bond depositor. That one's not very compelling. I mean, obviously, that has her collaterally involved with her son's case as she posted bond for her kid. But I mean, the real question there, because if she answers yes to the fact that her son was charged with felony battery, why we want jurors to answer honestly is because you can probe a little further. Just because you say yes doesn't automatically mean you're off the jury. What it means is like, okay, we need to ask some like further questions. Like when we get somebody who has had, like we have it all the time. We're family members, friends, acquaintances have been involved in a crime or a victim of a crime that's similar to the one that's at the bar. And the first thing that you're going to ask, well, has that impacted your ability to be unbiased and objective? And sometimes you'll get very honest jurors, which again we always want, and they'll say, yeah, like I think I'll have a very hard time being objective and unbiased. I've got long thoughts on this, and I have very set in stone feelings about it. And I'm concerned that I'm going to be able to sit here and not have that bias affect me, which God, man, I like appreciate those answers so much. Like I tell the jurors, I'm like, thank you so much for being honest. Like that's really all we can ask for. So on March 18th, juror 15 filed a petition for injunction for protection against domestic violence against Mr. Blank in the 12th Circuit Court in and for Manatee County, case number blank. The allegations of the latest act of violence or threat of violence provided that, quote, redacted, quote, grabbed juror 15 by her hair and repeatedly hit her in the face, causing a black eye, damage inside of her mouth, and a swollen face. And a copy of the petition attached here too is Exhibit D. Now, again, I think that was a little long in the tooth, but it doesn't matter. I mean, this woman was a victim of domestic violence. and how does that play for Benefield? I don't know. I mean, since she was a victim, if she is of the mindset that Benefield is full of shit and that, she was the one who was really the puppet master in that situation, that she, married a wealthy dude or a guy with some money in order to get what she was trying to get, which was her own studio, ballet studio opened up, and has this kid, sends him off to get a reversal of his vasectomy. you know he has a kid. It's like, and then she thinks that she's using the system as a sword as opposed to its intent, which is a shield, to shield and protect true victims of domestic violence. Then obviously that's going to have a major impact on the way she's going to feel about this case. You know what I mean? So it's like, or the other way around. If she believed what Benefield and her lawyer were putting out there during the trial, that she was, but I mean, I think that the jury verdict speaks for itself. I mean, they came back, they didn't go for the the second degree murder, but they came back with the manslaughter with firearm, which carried a massive sentence, and she got every bit of it. So, I mean, it's important. Like, the fact is that you just need to be able to rely on jurors to be honest about that kind of stuff, because theoretically, I think the more likely scenario is, had she answered honestly during voir dire, one of the two sides would have excused her with a challenge. They would have first asked for cause. If the judge then tried to rehabilitate the juror and said, "Look, we understand that you've had this in your life. Do you think that you'll be able to sit here and be objective and unbiased and follow the law?" And she answers yes. Then typically the judge is going to consider that juror to be rehabilitated, and the for cause will be denied. And at that point, you've got to use a challenge to get rid of her, right? Like, you're just not going to take a chance by keeping somebody that is a victim of domestic violence on the jury. It's kind of shitting where you eat a little bit. It's too close. Hits too close to home. You can't take that chance. So, I mean, that's a big one. That's a big one for me. Much more relevant than the aspect of her son being involved and a named defendant and her posting bond. So, jury 15 was a respondent in a petition for an injunction for protection against domestic violence, as well. So, respondent means that her partner also filed a cross petition, it sounds like, in that. Now, in Illinois, we can't have cross petitions for protection, orders of protection. Like, we ban that, because that's what was happening all the time. You get it where you get competing petitions where both are just saying that one or the other did it. So it was always, in Illinois, it's the first to the courtroom, first to the courthouse to file. That's the one that uh, is set in stone, and that blocks the other party from being able to file here, which I think is the right approach. Because once you get, like, competing petitions, it becomes very sticky. And I think that there's something to be said for the person who comes forward first. Because once you involve yourselves in this, once you bring it to the courts, or once law enforcement is called in on a DV call, it's out there, you know, and it's not going anywhere. You've decided to make your private life very public. And obviously, in situations where, it's obviously warranted, in the sense that the abuse was exceptionally violent, and that person needs to be arrested. Like, I've had it where, they're calling the police when one or the other grabs their phone out of their hand. Like, to me, I'm like, yeah, I mean, that's a shitty thing to do, but, like, maybe just let cooler heads prevail for a little bit, go into different rooms before you start injecting law enforcement into your life. Because once that happens, it creates a whole thing. So, I mean, there's just all kinds of things that you can get law enforcement involved with that I don't necessarily believe. Like, obviously, physical abuse always, but for other things, I don't know. I don't know. So again, she was a respondent in a petition for an injunction against domestic violence filed on September 2nd, redaction by her ex, seeking protection for himself and their minor child in the 12th Judicial Circuit Court in and for Manatee County. So, like you can see right there, I mean, it's like not too dissimilar from what was going on in the Benefield trial. You've got her filing, you've got him counter filing saying it's her. So it's like this trial would have hit home for her in a lot of different ways, I would imagine. Um, okay, so a copy of that petition is attached here too. So and it provides in part that juror 15 being threatening and violent, including cussing, slamming doors, threatening, and throwing things at him. B requested that his son come and stay with him until juror 15 could get some help. Juror 15 attempted suicide and was hospitalized on or about July 18th. She called and told Mr. Blank that she was going to kill herself. Constant harassment and threats to his wife and himself. So this guy's obviously remarried. D, fear that the juror 15 might try to take his son's life along with hers the next time she tries to kill herself. Jeez. Request to keep his son until juror 15 as well. Specifically, he requested supervised visitation until juror 15 showed that she was stable mentally and financially. 13, juror 15 was also responded in another petition for injunction for protection against DV, filed on April 23rd, redaction by her ex, seeking protection on behalf of their minor child in the 12th Judicial for Manatee. And that provides in part A, that juror 15 picked up his son by the arms and slammed him against the wall. B, that the minor child, while visiting with blank, expressed that he was afraid to go home. C, a report of child abuse filled with the blank police department. D, juror 15's boyfriend threatened to hunt blank down and kill him. E, ongoing investigation by CPS. F, blank was seeking custody. And then G, the minor child was showing signs of being violent. So obviously, that's all problematic stuff, right? I mean, it's very problematic stuff. So, and if you guys are late to the party, don't be mad at me. They're not streaming it. We tried to get on the Zoom, couldn't do it. So we had to pivot and we're reading what they're arguing about in there today. I'm surprised it's not being covered. I think a lot of resources are being spent on getting set up for the Adelson trial, which is starting tomorrow with jury selection. So that's my best guess. Still would have been nice to see this. So it's an important issue. So 15, 14, juror 15's failure to reveal this information during voir dire amounts to juror misconduct and subjects the verdict to legal challenge, entitling Miss Benefield to a new trial. 15, this motion is filed within the 10-day period prescribed by Rule 3.575 to address this urgent matter. Then, given the nature of the alleged misconduct, Ms. Benefield asserts that there is reason to believe that the verdict is subject to legal challenge on multiple grounds, including but not limited to A, juror misconduct, B, introduction of extraneous prejudicial information, C, influences external to the evidence presented during the trial that may have influenced the verdict, which I think is legitimate. It's one thing for lawyers just to file stuff. Like I'm saying, anything that's going on with the jurors is a problem. It's a real problem. It's like I said, and unfortunately, my feeling on Murdoch is that that dude's going to get a new trial. It's going to be a huge waste of time and money because it's going to be the same verdict. But I mean, you just cannot create precedent that it's okay for the clerk, the elected official, to be chatting with the jurors about the case, about the facts of the case, about guilt or innocence. You can't set that precedent. I think that the Supreme Court down there is going to have to give them a new trial. I mean, would I be stunned if they don't? No, but it's like it's not going away. They're going to keep throwing it, you know, up the chain. If it gets denied by them, they're going to go federal and they're going to try to file it there, and the federal courts will have long thoughts on it, you know. I mean, that's kind of the purpose of being able to file federally if you can't get any kind of resolution in a state. All right, so D, violation of jury sequestration. E, violation of the defendant's Sixth and 14th Amendment rights. F, jurors potentially receiving evidence outside of court proceedings to the detriment of the defendant's substantial rights. 17, the integrity of the judicial process and Ms. Benefield's constitutional rights are at stake. This court has both the authority and the responsibility to investigate this matter fully, including granting permission to interview all jurors who served on this case, to wit, redactions across the board. Now, this is different. We have a different circumstance than we do over in the Karen Reed case, where again, we have juror issues potentially. Not so much that they've been compromised or that they were conducting misconduct, but instead that they rendered verdicts. The problem there for the defense is, and I said it immediately, Allie and I both said it, is that we felt that they waived. They didn't object. They had to object. I reject this notion that they didn't have time to do it. They had plenty of time to do it. I don't wait for judges. Allie and I cannot wait for judges to say, okay, does anybody have any object? No. Yeah, I mean, you object, you get it on the record. And again, it's easy to sit on the sidelines as like an armchair quarterback, just saying, oh, this is what I would have done. Because when you're in that moment, who knows what's going through your mind? I mean, I've heard people intimate that, maybe they were afraid of what the answer was. I don't think that that's the case. I think more likely than not that they were taking it as a win. They knew that this thing was going to get booted. It's going to be a mistrial. And they were hoping to do their work in this period of time between now and the new trial to try to get something done, to try to convince the Commonwealth not to move forward on that. This is different. This is different. This isn't a matter of the defense didn't object at the time, and there's no easy way for the judge to be able to avoid dealing with this. I think in this situation, the judge is going to be required to have an evidentiary hearing. I think they're going to have to get these jurors in. They're going to have to talk to them. They're going to have to talk to Hoodie Guy. They're going to have to talk to his sister. They're going to have to talk to Juror 15, whether it be in an open hearing, whether it be in camera with the judge alone with the jurors. I don't know. But it needs to be on the record, and it needs to be looked into, because to me, especially Juror 15, and obviously the concept of somebody sneaking a phone in, which is verboten, it's not allowed. Hoodie Guy is the brother, Leslie, of one of the jurors that apparently the juror snuck a flip phone in, which I guess didn't set off the metal detector when you walk in. And apparently she was giving her brother blow by blow updates in real time, texting him from the jurors room. How wasn't, like, old flip phones, you had to do the super annoying, I'm pressing all the buttons in order to text. It took me forever, as you can imagine. I was not like an adamant texter back when you had to do that. Like, had to go through ABC, DEF in order to spell words. It was annoying. But somebody clearly was in the jury room doing that. How that was happening without any of the other jurors noticing it is really weird, strange to me. All right, so this is the wherefore clause. Every motion you'll ever see always has a wherefore clause, and that's what they're asking for. So this is what they're asking for, the defense. A, that they grant permission to interview all jurors who served on this case. Specifically, looks like quite a few. 1, 2, 3, 4, 5, 6. Looks like all 6. B, expeditiously set a time and a place for the interviews to be conducted in the presence of the court and the parties. So they're essentially asking for an evidentiary hearing. That's what they're like. It's a little to interview the jurors. Sounds like they should just ask for a flat out evidentiary hearing. I mean, maybe in Florida it's the same thing. It's clearly they want it to take place in court. Uh, See that the summons the jurors to appear at the time and place for the set for the interviews, and then grant any other relief this court deems just and proper under the circumstances. So that's the motion. They then filed a supplement. So they gave this is their notice uh to the appellate court addressing. So they have to they're letting the appellate court know what's going on. Because remember, there is a like a hard and fast notice of appeal deadline that if you blow it, you've destroyed your client's ability to appeal. So it's a big no-no. Um, so this looks like they just cited some case law here. I'm not going to read through it. All right. So this is basically supplementing their motion. Instead of doing a memo, they just basically put an opinion or two up there. Okay. And sent it to the court for guidance, saying that these are the cases that are germane to the issue at hand. All right. And then we had a couple of filings to in response by the state. So this is the state's objection to the defense motion to interview the jurors. And Ed Brodsky, state attorney for the 12th, by and through undersigned ASA, moves this honorable court to deny the defense's motion to interview jurors and would state as follows. See, to me, like, I don't know how this sits with y'all. And again, obviously I'm a defense attorney, so it's like I've got very long thoughts on it. It's just like this is where you worry about whether or not prosecutors care about justice or convictions. Like, if there's something wrong with the process during deliberations or the jurors are doing things that they're not allowed to do, I find it distasteful for the state to be saying, no, well, we got our verdict, so it's fine. It's fine. Like I have a problem with it. I just have a problem with it. It's like we all are in the same boat in terms of the state and the defense in terms of wanting fair trials to happen because we don't want retrials to happen. So I don't know. All right, so they responded that the jury reached a verdict in this case on July 30th of 2024. The defendant filed this motion to interview jurors pursuant to 3.575 on the 9th of August, which appears to be timely filed. The Florida Rules of Crim Pro 3.575 permits a party who has reason to believe that the verdict may be subject to legal challenge to move the court for an order permitting an interview of a juror or jurors to so determine. And they cite the case, a 91 case. However, in the light of strong public policy considerations, Florida law only allows juror interviews in limited circumstances where, quote, the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. And they cite Hamilton, a 91 case. Four, juror interviews are unnecessary. Quote, when an unreasonable allegation of juror misconduct is made and the defendant fails to allege facts establishing a prima facie argument for prejudice. Hamilton at 130. Five, the defense motion contains two forms of alleged juror misconduct: juror non-disclosure and the presence of a cell phone in the jury deliberation room. The defense has failed to allege facts establishing a prima facie argument for prejudice. Each ground will be addressed separately. Let me get this on scroll. So the juror non-disclosure. The defense alleges that juror 15 was untruthful on the juror questionnaire and failed to disclose her involvement in child custody / domestic violence abuse matters. In determining whether a juror's non-disclosure of information during voir dire warrants a new trial, courts have generally utilized a three-part test. First, The complaining party must establish that the information is relevant and material to jury service in the case. Second, that the juror concealed the information during questioning. And lastly, that the failure to disclose the information was not attributable to the complaining party's lack of diligence. Okay. Okay. So the defense alleges three areas that juror 15 was untruthful. The allegation that she did not disclose, one, that she has been a victim of domestic battery in the past; two, that her son had been previously charged with a felony domestic battery; and three, that she had involvement in child custody slash domestic violence abuse matters. Paragraph 10 of the motion seems to indicate that juror 15 answered untruthfully on the jury questionnaire as to the first two issues above. As a preliminary matter, the jury questionnaire has not been produced nor described in the motion, so it is unclear if the allegation is that juror 15 checked the wrong box on the questionnaire or failed to answer completely. So, as to number one, to assume that juror 15 was deliberately untruthful in answering this question as opposed to merely misunderstanding or misreading the question is pure speculation. The motion does not provide any information about what happened at the charge. Was it filed by the state? Did it go to court? Was it not prosecuted? And that's why the juror did not think identifying herself as a victim was appropriate. There is no evidence that the juror deliberately withheld the information. However, assuming arguendo that she deliberately misrepresented the truth, the defense has failed to establish a prima facie argument for prejudice as required under Hamilton. The defense has made no representation that it would have used a preemptory strike on the juror had the information been provided. On the contrary, it would seem reasonable to assume that a juror who was previously a victim of domestic violence would have been sympathetic to the defense's theory of the case and potentially biased against the state. I mean, it cuts both ways, right? It's exactly what I was saying. It's one of those things where you don't know unless you start asking the questions. So as such, now I don't know how they operate in Florida. So for instance, we do not get to keep the juror questionnaires when we are done selecting a jury. They collect them all and they're all numbered, and they don't want us having the jurors' information. So, they collect them. We don't get to keep them. So it seems like the state would have been looking at the same thing. It seems like they're kind of calling bullshit on the defense for not including the information that was on the questionnaire. But if the state had that information and it was the way that they were arguing it in terms of was it was it a lie or was it just not filled in? If they had that answer, that they would have included in their filing themselves. So, it's like that argument kind of rings hollow to me. So, as such, the defense has failed to establish that this information was relevant and material to the juror's jury service, and therefore has not made a prima facie showing of prejudice. As to the son's alleged previous charge, the defense motion indicates that the juror 15 responded untruthfully. The question, have you or a member of your family immediately been a victim of a crime? This question does not address anyone being charged with the crime. The defense makes no representation that she inappropriately checked an answer that applies to her son being charged with the crime. Therefore, the defense has failed to allege a prima facie argument for any misconduct or concealment related to this fact. Now, I don't know, Dizzy, do you know how the defense figured this out? Because I mean, essentially, what we do after a guilty verdict, like if we're not able to speak with the jurors, like if they're not wanting to talk with us, we do have their names. Sometimes we will dig in to see, if there's anything out there. It's part of our job to make sure that the jury was on the up and up. So I mean, they may have done some digging. They may have plugged her name in some various dockets around the state. Yeah, that's Allie said they must have investigated. Yeah, that's what I'm saying. And then they probably pulled up her name, like if it was somewhere in the 12th, no matter what courthouse it was in, it's going to pop up on the docket and they're going to see it. And then when they start digging in, I mean, pleadings are all public, you know? So, like, it would have been right there for them. So, because it sounds like neither side question this juror about any of that stuff, which to me indicates probably, if I had to guess, that she didn't answer, uh, or that she did answer and she said no as opposed to not answering. Like if you're going through, like, because when we're questioning during voir dire, I have the questionnaires in front of me and I'm looking through them, like when they have like the panel in there. So if they have like a 4 or 6 juror panel of people that you're questioning, I'll have the sheet in front of me. I'll kind of be flipping through. In a DV case, if they've asked that question, if she's left it blank, I would think that both sides, one or the other side, would have asked the question. Oh, I noticed that you left this blank. What does that mean? You know what I mean? But so that makes me think that they probably answered no. But like, I mean, that doesn't need to be a mystery. The clerk of court has the sheets. Look at the sheets. See what the sheets say. I mean, if I'm the judge, I'm saying, all right, give me the sheets. I need to look at the sheets. And then if the juror lied, it's a problem. If the juror left it blank, then maybe I think the state's argument has some merit. You know, defense should have asked. Somebody should have asked, why is this blank? What's that mean? Did you forget to fill this one in? It's a DV case. We need to know the answer to this particular question. So, as to number three, the defense alleges that 15 was untruthful by falsely representing that she had no involvement in the child custody domestic violence abuse matters, but the motion fails to allege how the juror falsely represented it. Since there is no question on the juror questionnaire pertaining to these matters, it can only be assumed that the allegation is that the juror made false representations during voir dire. After a thorough review of the voir dire transcript, attached trans, there is no evidence to support that juror 15 was untruthful. The state asked the panel if anyone had any disputes with a significant other about child custody. So that's transcript page 233, line 9. Several paddles were raised, um, but there is no indication in the record of which paddles, and the state makes no representation that it spoke to everyone who raised their paddles. On page 234, line 23 of the transcript, the state asked, quote, has anyone ever had a heated custody battle with anyone? And again, there is no record of whose paddles were raised. During voir dire, the defense never asked the panel any questions about custody or injunctions. The defense did ask if anyone had been involved in domestic violence courts. And according to Mr. Taylor's record response, 2 people raised their paddles. However, Mr. Taylor did not identify on the record who raised their paddles or follow up with any questions. Then he moved on to another question. It's a problem. It's a problem for the defense. So, based on the review of the transcripts, there is no evidence that juror 15 withheld any information. On the contrary, the record establishes that had defense counsel exercised due diligence and followed up on the questions asked, he may have received the answers he sought. As a result, none of the required 3 parts of the De La Rosa test are satisfied, and therefore the defense has failed to make a prima facie case of prejudice as required by Hamilton. Now, so that last part's compelling. Like if those questions were asked, and it sounds like people had paddles, you know, um, and the defense, if they whiffed on it, if 2 people raise their paddles, and we don't know if one of those is 15, but the defense didn't follow up, which is bizarre, frankly, and the state. Like I think it's bizarre from both sides. Like if you're the state, you know what Benefield's defense is. It's basically battered spouse syndrome that, this guy was a lunatic and like I thought he was going to kill me that night and I thought it was over and that's why I did what I did. So it's like, both sides should be asking those questions because the way that a juror feels about DV and how it's affected their lives. And, I mean, you could have a situation where you have a victim of domestic violence and the courts failed them miserably. Like we've had many jurors like, yeah, I was a victim and the courts didn't do shit about it. And now I'm salty about the system in general. I mean, everyone has to ask questions. It's not just a defense thing. It's both sides. Believe me, there's been plenty of victims of DV that the courts or law enforcement have failed them. So, like for the state to be saying, "Oh, well, they're the ones asking it, they should have asked the question." I think that everybody would have wanted to ask questions. So the defense alleges that the comments on court TV thought it was it Court TV? I thought it was Law and Crime. Alleges the comments on Court TV proved that the juror brought an unauthorized flip phone, cell phone into jury deliberations, and that this alone establishes juror misconduct and a rebuttable presumption of prejudice. The defense motion and accompanying screenshots do no such thing. The defense only benefits from the rebuttable presumption of prejudice after juror misconduct is established. And that's Norman v. Gloria Farms, Inc., a 96 case. The defense motion contains nothing more than unsubstantiated suspicion and conjecture, and therefore does, I think, I think they meant to put a not in there, does not establish a prima facie case of misconduct. First, the comments presented do not identify the speaker other than that hoodie guy. There is no other identifying information, and the source should therefore be afforded the same credibility as any other anonymous source. It's legit. I mean, it could be a guy that's just acting like he knows shit. There's plenty of people on social media acting like they know shit. This anonymous source claims to be the brother of one of the jurors and that she is texting him from the jury room on a flip phone. However, one of his comments itself puts this assertion in doubt. He says, she just texted me this per sources. 5-1 guilty with man stuck on not guilty or manslaughter. Right. Like the per sources thing was weird to me too. If the reporting person were in fact a juror, why would she text information that begins with per sources? It's weird. It's a weird response. Unless she was like, I need you to say it this way. So it's not evident that it's a juror that's sending you this. Put per sources. But what source could it be? There are no sources in a jury room, a jury deliberation room. There's no sources. Like the bailiff or the clerk, whoever is assigned to kind of hand holding the jurors and making sure they have everything they need, that person would be the only source. It is far more likely that this anonymous source was getting information from another source entirely or completely fabricating the information and saying that he was the brother of a juror to receive attention on a social media site. It's possible, definitely possible. During the trial, the court instructed the jury on multiple occasions that they were not to communicate with anyone or receive information about the case outside of court, and inquired of the jury after each break to assure that they were following these rules. That's true. We know Judge White was doing that big time. We know that he was doing it. Like every single time they came back from court, he was super diligent about it. Like incredibly, incredibly diligent about it. So that's true. Pocket, hot pocket. Now you guys remember who Judge White is, right? That's all we need. It's like a Pavlov's dog type thing right there. You play the hot pocket sound clip, and you know exactly what judge we're talking about. So during the trial, the court instructed the jury on multiple occasions they were not to communicate with anyone or receive information about the case outside of court, and inquired of the jury after each break to assure that they were following the rules. Each time, the members of the jury indicated that they had followed the rules. During deliberations, the court did not receive any messages from the jury indicating that one of the jurors was violating the rules. No, nor was there any other indication of wrongdoing. That's what I'm saying. Like, maybe one thing if we had, somebody had their like iPhone or Droid out and they're like texting and they're real good at texting and they could do it without looking under the table, like with a whole flip phone. That's a whole thing. That's a whole thing. That's hard to do. Send texts out, pressing on the buttons, click, 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 click. But assuming arguendo that the juror had a flip phone and was texting this person, the only evidence available indicated that the juror did nothing more than provide outgoing updates. There is no evidence of any incoming information. Not every alleged juror impropriety can constitute a matter extrinsic to the verdict, sufficient to allow jury inquiry, unless there is a showing of improper considerations, mistaken legal or factual understandings, or erroneous reasoning by a jury. Mailer by and through mailer versus Baptist Hospital, an 89 case. In order to constitute juror misconduct sufficient to allow post-trial jury inquiry, the objective must have been committed by a juror which compromised the integrity of the fact-finding process. At 1162. Examples: one, a juror was approached by a party, his agent, or attorneys. Two, witnesses or others conversed about the facts and merits of the case in the presence of jurors. Three, the verdict was determined by aggregation and average, or by lot, game, or chance, or other improper manner. Oh, here's what we're going to do. We are going to Rochambeau for the verdict. Four, a juror went to the scene and reported his observations to fellow jurors. Five, a juror had personal knowledge of the case and conveyed this knowledge to the jury. There is no allegation or indication that the juror received any unauthorized information from any outside sources. Additionally, there is no evidence that this quote flip phone had internet access or that it was used to gather unauthorized information of any kind. There is no evidence that the other jurors even knew of the phone or were influenced by it. The defense has failed to make a prima facie case showing, or a prima facie showing, of juror misconduct, or that the alleged misconduct improperly influenced jury members, and therefore has not made the prima facie showing of prejudice. Wherefore, state of Florida respectfully requests that you deny the defendant's motion to interview the jurors. All right, and then they included a little 3-pager here. This is the motion to strike defendant's motion to interview the jurors. So Ed Brodsky coming back again. Again, the jury reached a verdict on July 30th, 2024. Defendant filed this motion to interview pursuant to 3.575 on the 9th of August, 2024. However, defendant's motion is legally insufficient as a matter of law because the motion has made no sworn allegations as required by the Supreme Court of Florida, Crane v. State, citing Green v. State, noting that, quote, juror interviews are not permissible unless the moving party has made sworn allegations via a affidavit. We know the affidavits. You saw the affidavits in Reed, right? Yannetti and Jackson filing all kinds of affidavits. That, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. So, four, additionally, even if the allegations were sworn, the defendant has failed to allege specifically how these allegations, if true, were so prejudicial as to vitiate the entire proceeding. Juror interviews are unnecessary, quote, when the unreasonable allegation, oops, hold on, I gotta flip this to the right view. Enable scrolling. Okay. When an unreasonable allegation of juror misconduct is made and the defendant fails to allege facts establishing a prima facie argument for prejudice, again, citing Hamilton. Facts and argument in the defendant's motion do not establish a prima facie argument for prejudice. The motion merely alleges that, if true, these behaviors were violations of a juror's sworn duty, or that generally the behaviors impacted the fairness of the proceedings. Without more, these allegations are merely speculative and conclusory. So, in addition, the general insufficiency of the motion, the defendant has utterly failed to allege any juror misconduct pertaining to Juror 15's non-disclosure of being a previous respondent in an injunction. The motion fails to allege how the juror misrepresented these facts, whether by questionnaire or jury questioning. Should also be noted that no official transcript of the jury selection has been released. The state has requested a transcript, but it is not available yet. Wherefore, state respectfully requests state's motion to strike be granted. So there you go. That's what we got. That is what we got. What do y'all think? What do y'all think? Yeah, it's a shame. I would have liked to have seen this. I don't know if they're going to. I don't know if they will end up, putting this on a replay. I hope so. It's important. It's interesting arguments. I want to hear both sides. I was a little salty with the state, but then they came with some receipts. Had some legitimate arguments there. Because the part in terms of the questioning during voir dire, that's what I was talking about. Did it come up? If it came up, like if 15 was one of the ones holding the paddle up, the defense didn't do anything. It's on the defense. That's the entire purpose of why hold the paddle? Why give them paddles if they're if you're going to ask a question like a preface type question and then you're not going to follow it up? Both sides, though, really. So I don't know. I don't know, like that 15, the Juror 15 one really has more legs to me than the phone thing. Phone thing is pretty speculative. Like the phone thing probably makes for more interesting banner or more interesting banter on social media just because it's like tech driven. Somebody sneaking a phone in, they're making messages, they're communicating with their sister and it's a little sexier of an issue on its face. But I think in terms of what has more legs, I think it's probably the Juror 15 issues. And it sounds like they haven't gotten the full transcript, so that's interesting. Um, the official transcript of the jury selection process has not been released. I mean, they were citing for deer, so they must have gotten some version of it. I don't know, unless they were taking notes. But it sounds like they were looking at a transcript because they cited it. All right, I got a few questions here. Um, Question from Kraken. What's up, Kraken? Regarding sequestering witnesses when doing a deposition and affidavit to compare and contrast while testifying be a possible resolve. Yeah, I mean, it could be. Wouldn't doing a DAP and affidavit to compare and contrast while testifying be a possible resolve? So are you suggesting that, I mean, some states you're doing DAPs, like Illinois is not a DAP state for in criminal cases, but civil cases we can depose everybody. I don't know if that's a resolve. Like, because I think that the ultimate issue with respect to sequestering witnesses is that, I mean, the witnesses aren't going to be reading the other witnesses' deposition transcripts. So, I mean, I don't know. Maybe flesh that out a little more, Crack, and maybe I'm not getting what your bigger point is. I want to answer it, but I don't know if I can. Crocheting bat. So awesome handle. To me, the big question is this happening more often or is it just discovered more now? I'm leaning towards that it's more the latter. I agree. I think it's just getting discovered more now. Um, it's kind of like what I was talking about, with cops beating people of color for the last forever, that everyone really didn't know was a thing because people were just ignoring what people of color were saying, how the cops are treating them until the Rodney King video came out. So, yeah, I think the technology and just the ability to be able to access information that did not exist in the past has made it way easier to sniff stuff like this out, you know? I mean, back in the old days before the internet, you had to go to the books. There was no way to find this shit out. There's no way. But I also had to worry less about them being able to access what happened the previous day in court because nothing was being streamed. So it's like, it was basically left to, okay, well, they're getting their information from the media via either the news on TV or the newspaper. Like that was our biggest concerns back then. Now it's a whole different beast. It's a whole different beast, you know? So but yeah, I definitely think it's just being discovered more now. I think that they probably had less of an ability, but, like, I mean, even back in the day, like, even when you look at old cases, old high profile cases that got a ton of publicity, there were facts out there that you wouldn't want the jury talking about. So, I mean, that's existed. Like, and they've been reporting on crimes and trials and murders for as long as they've been using the printing press and making newspapers and reporting on things. So, I mean, it's existed. I think it's far more easily accessible in terms of the amount of information that people could get. The ability to be able to go into a court dockets, and pull up things that did not exist. Like in the old days, you have to drive down to the courthouse, go to the clerk's office, get a number, sit in line, and pay to have a transcript copied for you if you wanted something about a case. It's like that's just different times, very, very different times. So, I mean, it's what I'm saying. Like, to me, there's two pressing issues that our technology has to be which have to be addressed, and it's AI. Like the AI shit that's about to start coming down the pike is going to blow your minds. I mean, the deep fake stuff, whether it be voice, whether it be video, like, I mean, they're going to be able to frame people up. And I'm not even talking about law enforcement. I'm talking about other people, salty people, like internet weirdos that can't stand somebody online, so they make videos and of like people that they don't like doing horrible shit. It's like it's going to have to be addressed. It's going to have to be looked at. And the voice stuff is equally scary, if not scarier. Because it's really, really hard to tell. And if you get people that can't afford to pay like some kind of top line expert that can, sniff out deep fakes, I mean, you're screwed, you know? Imagine you're a broke defendant and somebody like has come up with a witness statement or some recording, some purported recording of you making an admission. You're like, I never said that. Where did that come from? And like you're trying to disprove it, and you've got no money to hire an expert that's worth a shit who's going to be able to it's like that thing, and how social media directly is impacting trials in the sense that people have the ability to be able to watch the trials that they're either sitting in as jurors, which is what really is the scariest, followed closely behind by the witnesses that they're watching other testimony. I mean, like if you get a heads up, like if you're a state witness and you're able to go home or you're back in your hotel room that night and you're watching who testified that, the 2 days before you, and what they're saying, I mean, it can absolutely affect how you testify. It's a scary proposition. Just is. Just is. Joanne, what's up, Joanne? Do you think things like this are coming to light due to the close eyes from true crime community? Yeah, definitely. Definitely. And it's like there's all kinds of creators out there, right? There's those that like kind of live in the world of speculating and trying to solve cases before trial. That's not what we do. It's not our thing. We're more the law nerds. Like I'm just trying to let people know that our constitutional rights matter and you should give a shit, whether you're somebody who thinks you're ever going to be arrested or not. You're not. I'm no criminal. I don't care. You should care. It's the fabric of our country. So, Constitution matters, but like those folks out there that dig, and speculate and put their speculation like out to the world, it's dangerous. Like all the people like on the other side of the Allen thing that are torch and pitchfork that are speculating that have him nailed as guilty and accusing me of saying he's innocent. I'm like, I've said no goddamn such thing. Said his PCA leans innocent. That's based on 20 years of trying cases. I have no idea what the evidence is. So, like, if you follow my content, you know that you should never be saying that I'm saying somebody's innocent until trial, because that's always the only thing I ever say. You cannot know. Everything has to be vetted at trial. I mean, I could not be more clear on my stance with that. Like, that's facts. If anyone wants to go on any of my content and tell me a place where I'm, convicting somebody prior to trial without the evidence being vetted, like the closest I ever get, like to where I'm like, oh man, they like is like probably Hewerman. You get a case like Hewerman, you read that the bail application where they really lay out the evidence that they have, and it's powerful. You got DNA evidence. You've got all of the data from the devices. It's you've got him in certain places. You got the wife and the family guy. It's like that dude, but still, it's got to go to trial. They're going to vet it, but that bail application leans heavy as a mofo. That it leans heavy as a it's like tilting. It's like if it was an arm wrestling match based just on the bail application, like the state would have Rex Hewerman almost down in the you're done position, because like that thing's super powerful. That being said, it's all got to be vetted at trial still. If that even goes to trial. Like that's one where you know, like I don't know. I don't know if that's going to go to trial. I don't know if they're going to plead that thing out. Like you have to know in a case like Huerman that the state is probably willing to give some kind of concession to Huerman in order for him to give information. Like I mean, that dude's got to realize he's never getting out. Yeah, but he might not. Like Gacy always thought he was walking. They're delusional. These guys like this, they just have like they're not grounded in reality in terms of what's going on. It's like they're like, oh, like I mean, the Gacy tapes. The guy's talking about what he's going to do when he's out. Yeah, I'm probably not going to be a contractor. I'm not going to be like the same social guy I was. Guy's just delusional. Gave 5 confessions. Like, and you think you're walking, bro? It's not happening. So I don't know. I don't know. All right. So if this thing ever, if they, so jury, they're going to start picking the jury tomorrow. I'm assuming around 9. They anticipate that it'll probably take 2 to 3 days. The guesstimate right now by the courts is that uh, they are going to have opening arguments my first day in the UK. So we're going to try to figure out if we should even bother streaming it on our channel. Like the reason that I would do that is just so y'all have a place to come and hang and talk shit. You know, it's I mean that might be worth it. So you guys will let me know in the you know like I'll post a poll in community page to whether or not you guys think that we should have them run because I would just have I'd torture Dizzy and have her just run it every day and let you guys sit in here and chat. If I can pop in, I'll pop in. Like I said, I plan on doing a few like fun lives, not work lives, while I'm in the UK. You know, like I would really, I'm going to really try to be able to. Um, I want to try to have a live with me doing my panel with Chris Hansen. That'll be cool. I got to ask the folks who put together the CrimeCon UK. Nancy's very cool. I could see her being cool about it. I mean, it's promoting CrimeCon UK, so all right. I think that'll do it. Solid 115. I apologize. I should have really checked more thoroughly to make sure this thing was streaming. Dizzy's like, "Ah, I can't find the stream anywhere, so she like sends me the clerk's number over there in Manatee. I call, talked to a few different people, and ultimately it sounded like the only way I was going to get it was if somebody gave me the Zoom. Um, uh, yeah, I don't. Is Jay planning to stream it? I don't know. I don't know. Like probably. I guess. Yeah, I don't know. I don't know. We'll figure it out. We'll figure it all out. Maybe we'll do. Maybe I'll see if Jay wants to do like a dual stream. Like, I just don't wanna be, like, off of YouTube for, like, a week straight because 'cause I'm probably not gonna be doing nighttime lives. That concept scares me just because of the algorithm. Gets angry, gets angry if you don't put content out. Gets very angry. So, alright, I think that's it. I don't see any more questions. I appreciate my mods so much. Thank you guys for being the best mods in the game. I love all of you. Uh, to Dizzy specifically, I adore you. Thank you for everything you do. And again, thank you for streaming that verdict Friday night when I was indisposed. Stuff like that. Long memory, Diz. Never forget like solids like that ever. So I appreciate you more than you know. And to you guys who I love, we had a great crowd here today. Please, please, please remember to share, like, subscribe. If you're on replay, make sure that you comment. All that kind of interaction gets us out the channel. We're growing. I think we have good content. We have an amazing community here that we're so proud that we've built. And, it's like it seems like attracts like usually. That's why I love you guys all so much. You guys are all just amazing people, all of you. So I thank you guys so much for hanging. I'm probably gonna do. I'll probably try to figure out something to do during the day tomorrow. I do want to do a Delphi because that's coming up October next month. That thing's coming down the pike, and it is a mess. It is a mess. So I'm thinking about doing like a kind of like a the case against and the case for Allen based on just the evidence that we know exists. Maybe I'll have Dizzy try to help me get some of that stuff together because I think in terms of filings, there's really I think we had a couple of rulings, but I think that we did the most recent order. So I'll figure it out. I'll figure it out. It's gotten to the point where I feel bad if you guys can't get together and hang. It's like I woke up this morning, and like I said, I'm adamant about not bothering Dizzy while I hope that she's rejuvenating on weekends. So, if she hits me up, that's one thing. I'm not going to hit her up because I want her to be able to rest because I know she works so freaking hard during the week. And I'm sure she's still working hard on the weekends, but I don't need to be in her shit bugging her. Oh, look, see, she sent a new one. Is it an idea, Diz? Let's see. What'd you send, Diz? I didn't see it. I don't know I don't know what she sent. Check your email. Just sent a new one at 1:44. Maybe it hasn't come through, Diz. I don't know what it is. Let's see. Yeah, the email hasn't come through, Dizzy. I don't know what it is, but I'm assuming a new one. What, Dizzy? Just tell me here in chat, and then we'll let the folks know. I got one. I got an email from Kraken came through. She's trying to help me figure out how to get my podcast over to YouTube. So that what was you? You guys are Dizzy. Oh, Kraken. Oh yeah. It was Kraken. I got your email, Kraken. Yes. Never mind. Yeah. So all right. I got that, Kraken. Yeah, you and I'll get together because I've had a hard time figuring out how to transition the RSS feed stuff over with the ads. And that's not something that I want to put on Dizzy and Mandy because it's pod shit, like RSS feed shit. So I don't want to put that on their plate. They're busy enough. I keep them busy enough to like that's like some technical stuff. But I would like for people to be able to listen to the straight up podcast that has no visuals, but listen to it on YouTube. I feel like I'm missing a huge amount of downloads that potentially some people just don't touch podcasts like in terms of going on like Apple or Spotify or podcatchers. They do it through YouTube. So yeah. I mean, I'm always confused, Bob. What's going on? Dizzy, I can't see your email. Well, it's because it's from Kraken, jackass. I mean, sometimes y'all, I'm just out here floating in the ether. But luckily, I have you guys to always let me know that I'm muted, to let me know that I'm screwing up text somehow. Oh, you guys would be lost. So, and that's true because again, thank you, mods. Love you. And thank you guys for hanging with us today. Remember, share, like, subscribe, comment. Share, like, subscribe, comment. All the time. All the time. It helps us get out there. Get the word out there. Be my people, my feet on the ground. Get us out there to the world. All right, you guys. You guys are the best because without you, I am just some super, super old man talking about tons and tons of cases. Talk to you next time. Probably tomorrow.
So